Now that you know this, it's time for a quiz. Now, how many of you are going to have a quiz tonight? We're going to have a quiz. What legislation did Congress pass prior to the 1962 school prayer case, which prohibited public school children in the state of Indiana from taking part in state government-sponsored voluntary school prayer? None. Question 2. What law has Congress passed after that same case, which prohibited public school children in the state of Indiana from taking part in state government-sponsored voluntary school prayer? None. There now, you know more about First Amendment jurisprudence, which is actually faithful to the Constitution, than most of the justices who have served on the Supreme Court during your lifetime. We could end our discussion here with the realization that regardless of the motives of those who have played such an important role in the divesting our culture of our Christian heritage. However, with regard to the specific issue of the 14th Amendment's supposed prohibition of school prayer and Bible reading, as well as the placement of the Ten Commandments on public property, there is an even more compelling case that proves beyond a reasonable doubt that the individual state's role in religion was never touched by the 14th Amendment. In 1876, 8 years after the ratification of the 14th Amendment, a resolution was considered in Congress that was intended to amend the Constitution of the United States. That resolution, offered by Congressman James Blaine, ultimately took the following form in the House of Representatives, quote, "No state shall make any law respecting an establishment of religion, or prohibiting the free exercise thereof, and no money raised by taxation in any state for the support of the public schools, or derived from any public fund, therefore, shall ever be under the control of any religious sect, nor shall any money so raised ever be divided between religious sects or denominations. This article shall not vest, enlarge, or diminish legislative power in the Congress," end quote. The Senate provision took this form, among other things, quote, "No state shall make any law respecting the establishment of religion or prohibiting the free exercise thereof, and no religious test shall be required as a qualification to any office or public trust under any state. And no such particular creeds or tenets shall be read or taught in any school or institution, supported in whole or in part by such revenue or loan of credit. This article shall not be construed to prohibit the reading of the Bible in any school or institution," end quote. While the resolution received the necessary two-thirds support in the House, the Senate version fell 4 votes shy of the two-thirds required to proceed with the amendment process. The common language of each version specifically, quote, "No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof," end quote, contains language obviously taken directly from the First Amendment of the United States Constitution, the only exception being the replacement of the words "Congress shall make no" with the words "no state shall make any." If the 14th Amendment, as approved by Congress in 1866, already prohibited the voluntary recitation of public school-sponsored prayer as an establishment of religion by the individual states, why was there a need for this proposed 16th Amendment, which explicitly stated no state shall make any law respecting an establishment of religion? By the way, did you catch that portion in the Senate proposal that stated, quote, "This article shall not be construed to prohibit the reading of the Bible in any school or institution," end quote. It is interesting, is it not, that this was not considered in 1963 when the Supreme Court opined that the 14th Amendment was Congress's way of prohibiting Bible reading curriculum in public schools. This was the 14th Amendment approved by Congress 10 years before the United States Senate attempted to enshrine in the Constitution its implicit endorsement of Bible reading in public schools. My friends, it is clear. The historical record and the plain language of the United States Constitution inform us that the Supreme Court has not only overstepped the boundaries laid down by the framers of that great document, the federal judiciary has just gotten it wrong. But this should not surprise us. The federal judiciary is inhabited by fallible human beings, just as is the Congress and the executive branches of our federal government, just as this podium is before you tonight. Knowing this, the framers created a federal judiciary that, while effectively appointed for life, is relatively powerless. In conclusion, if prayer or Bible reading in Elk Park Public Schools or the Ten Commandments part city property is prohibited, it is only prohibited based on an assumption. Now that assumption is either conscious or it's not. It's either informed or it's not. However, it is still only an assumption. That assumption is this. Once a federal court orders the termination of public school prayer or public school Bible reading, or once a federal court orders the removal of the Ten Commandments from public property, that order will be enforced by a president who agrees with the error of the court as a result of funding from a Congress who agrees with the error of the court. All three branches must act in agreement for those practices to be actually terminated, and do not let anyone tell you any different. To the extent we, the people, continue the elevation of persons who do not understand the United States Constitution to high office, the blame for the current state of affairs clearly rests with none other than we, the people. Thank you very much, and God bless.